Welcome to the debate. Today, we are examining the 2026 landscape of medical jurisprudence and forensic science. We're looking at this really fascinating ecosystem, one that serves as the critical bridge between, well, complex medical science and the halls of justice.
It really is, yeah. It's the ultimate intersection of biology and human law.
Precisely. And our central question for this discourse is this. Does the unprecedented accuracy of modern forensic technology, specifically DNA profiling and highly standardized medical legal protocols, does that create an infallible objective justice system? Or do the inescapable elements of human interpretation coupled with, these massively expanding biological databases introduce equally profound vulnerabilities and privacy concerns?
Right. And it's important to note right up front that this entire discourse emerges directly from the comprehensive treatise on medical jurisprudence, as well as the governing global standards across Pakistan's PFSA, the UK's Home Office, and the USA's FBI and Department of Justice.
Exactly. So my position in this discourse is that standardized, advanced forensic technologies have fundamentally secured absolute identification and objective truth in our justice system. The science has essentially removed the blindfold from justice.
And my position is that, regardless of this remarkable technological accuracy, forensic science remains inextricably bound to subjective human opinion, potential manipulation, and escalating privacy risks. The tools might be perfect, but the hands wielding them are not.
Let's start with the foundation of my perspective, which is deeply rooted in the empirical reality of our current era. We have achieved what I truly believe can only be described as technological infallibility in the realm of identification. In 2026, DNA has rightly earned the title of the silent witness. As our source literature notes, it is a witness that doesn't blink, and it certainly doesn't lie.
It's a powerful metaphor, I'll give you that.
But it's more than just rhetoric. It is anchored in the utilization of short tandem repeats, or STR analysis. Think of STR analysis like finding highly specific typos in a massive, sprawling manuscript. Human DNA is, 99.9% identical across our entire species. We're all reading from the same basic book.
Right.
But by targeting the specific sections where genetic sequences repeat, which vary wildly from person to person, we create a unique genetic fingerprint. The math behind this is staggering. We are looking at a 1 in a billion probability error rate.
The math is indeed precise.
And it's backed by rigorous global standardization, ensuring this accuracy isn't just theoretical. In the United States, we rely on the Daubert standard to ensure the reliability of scientific techniques in court. In the UK, the PACE Act governs forensic examinations. In Pakistan, the Punjab Forensic Science Agency, or PFSA, utilizes incredibly advanced 24 loci kits while maintaining strict ISO 17025 certification.
Which is a high bar.
Exactly. The ISO certification means perfectly calibrated instruments, controlled environments, and peer-reviewed data. We've officially moved past the era of guesswork and into an epoch of mathematical certainty.
I readily acknowledge the mathematical precision of STR analysis. A 1 in a billion error rate is an astonishing scientific achievement. But scientific precision doesn't automatically equate to systemic infallibility. The treatise explicitly points out a profound controversy here. Quote, "With great data comes great responsibility. As we collect more genetic profiles, the debate over privacy intensifies. You speak of this technology as if it exists in a pristine, flawless vacuum. It doesn't."
But the science itself.
The science relies entirely on human application. Look at how the treatise explicitly defines the medical legal expert. They are not defined as a witness of fact. They are defined as a witness of opinion. We can possess the most sophisticated tools on the planet. Take gas chromatography mass spectrometry, or GCMS. It sounds like science fiction, vaporizing the sample to measure the exact mass of its molecules, to detect poisoning under penal codes. Or look at the PowerPlex system, which is designed to miraculously extract DNA profiles from severely degraded, burned, or aged samples.
which are incredible tools for establishing truth.
They are. Yet every single one of those pristine outputs can be completely undermined by fabricated evidence, human bias, and the interpretive lens of the examiner. The silent witness may not lie, but the human beings interpreting its whispers certainly can, and frequently do.
I see why you think that, but let me give you a different perspective by building a structured argument around the concept of absolute identification. Let's look beyond just DNA to what the text actually calls the gold standard of identification, dactyloscopy, or fingerprinting.
The oldest reliable biometric.
Exactly. And it's a system of absolute, unshakable fautology. The classifications are immutable across the human race. Loops account for 65% of patterns, whorls for 30%, and arches for roughly 5%. And modern forensic investigators have perfected the capture of this data. Whether they are lifting latent prints, which are the invisible sweat and oil marks brought out via chemical reactions like ninhydrin or fine powder, or documenting patent prints left visibly in blood or ink, or casting plastic prints impressed into soft 3D surfaces like wax or clay. The physical reality of the individual is captured permanently.
The pathology is sound, yes.
Now elevate that physical certainty with the biological certainty of the global filer 24 loci amplification kits utilized in massive databases like CODIS in the US and the NDDNA in the UK. When you fuse fingerprinting with 24 distinct genetic markers, you are guaranteeing high conviction reliability. The system is structurally designed to remove the exact human error you're so concerned about by relying on quantifiable, reproducible biological and physical markers. You can't opine your way out of a 24 loci match combined with a whorl fingerprint at the scene.
That's a compelling argument, but have you considered the systemic and societal implications of how those exact markers are weaponized? You're focusing on the micro, the forensic accuracy, while missing the macro. Yes, the mathematical certainty is an achievement, but the databases housing this information have crossed a very dangerous critical threshold.
In what sense? They are tools for solving crimes.
They were tools for solving specific crimes. Now we are seeing the FBI and Department of Justice in the USA rapidly expanding CODIS with rapid DNA technology. In the UK, the Home Office is utilizing the nDNA DNA not just for matching a suspect to a crime scene, but for what is officially termed biometric crime prevention. Do you see the philosophical shift there? When we transition from investigating a specific committed crime to perpetually monitoring the biology of an entire citizenry, we cross a massive line into intense privacy violations.
But if the data is accurate, it simply acts as an objective filter. It clears the innocent as quickly as it identifies the guilty.
But it builds an architecture of surveillance that fundamentally assumes criminality. The collection of genetic data at this unprecedented scale is a profound societal vulnerability. It's no longer just about identifying a suspect, it is about the state holding the biological map of its populace. The treatise warns us about this. With great data comes great responsibility. We are trading the presumption of innocence for a biological dragnet.
That's an interesting point. Though I would frame it differently when we look at how the justice system actually processes physical evidence beyond just databases. Let's shift from broad identification to the very specific documentation of physical trauma, specifically the Medico-Legal Framework.
The medical examination of the living and the dead.
Right. The 14-point Medical Legal Case, or MLC protocol, is a phenomenal, rigorous methodology for documenting objective truth. Let's look at just point 14 of that protocol, identification marks. Before an examination even begins, the medical officer must document specific immutable marks on the subject. This alone prevents personation, ensuring that a defendant cannot essentially substitute one person for another in court.
Assuming the medical officer is diligent, yes.
And the methodologies have evolved so much. We are seeing incredible advancements like virtual CT and MRI autopsies in the USA and UK. These systems determine the cause versus manner of death without a single invasive dissection. It's basically seeing the crime scene of the body perfectly preserved in digital amber. You preserve the integrity of the evidence perfectly, forever. A jury can look at a 3D model of the trauma 10 years later without any degradation.
Virtual autopsies are certainly a brilliant step forward for evidence preservation.
Furthermore, look at the classification of injuries. Take Shajjah, which covers specific head and face injuries, under the Pakistani Penal Code, Section 337. The legal precision here is matched perfectly to the medical reality. It's not just a generic assault charge. The law meticulously scales the severity based on anatomical truth. On the lower end, you have Khafifah, where no bone is exposed. Then it scales up to Mudihah, where bone is exposed but not fractured. Then Hashima and Munakila.
Tracking the exact severity of the fracture?
Exactly. And it scales all the way up to Amma and finally Damiha. Damiha represents a severe fracture that actually ruptures the brain membrane. That specific, undeniable anatomical reality carries a punishment of up to 14 years and half Diyat as financial compensation. This isn't subjective. It is an exact structure translation of physical trauma into legal accountability.
I'm sorry, but I just don't buy that. Let me tell you why. You are continually portraying the MLC protocol and these legal codes as a flawless, mechanical process. But the reality on the ground is that it is deeply, fundamentally vulnerable to human manipulation at the very first step.
How so? The protocol explicitly demands objective measurement.
The protocol demands it, but human beings execute it. You mentioned the 14 points of the MLC. Let's look at a specific cross-examination strategy utilized by legal advocates every single day to expose these systemic vulnerabilities. A smart advocate will look directly at point 12 of the medical legal report, which records the exact date and time of examination. If there's a 48-hour delay between the alleged incident and the medical examination, it strongly suggests that the age of injury was completely fabricated.
A delay doesn't automatically imply fabrication. People delay seeking medical care for all sorts of reasons: shock, fear, lack of access.
True, but the entire system is plagued by the reality of fabricated, self-inflicted injuries designed to falsely charge an opponent with a serious offense. This isn't rare, it's a common tactic. Medical officers are forced to constantly hunt for these deceptions. They aren't just logging data, they are trying to outsmart human deceit. They have to look for superficial wounds on easily accessible parts of the body. Say, perfect parallel razor cuts on a non-dominant forearm. They must look for a suspicious lack of defense wounds on the hands,
which a trained forensic expert can easily identify.
but it requires subjective interpretation. They frequently find discrepancies where, for instance, a person claims they were slashed with a knife, but their clothing remains perfectly intact without a single tear, despite a severe skin injury beneath it. The legal classifications of Shajjah you mentioned, Khafifah No, are brilliant on paper, but they are only as reliable as the human being filling out the paperwork. If a medical officer is bribed, intimidated, or simply exhausted and biased, that rigorous legal scaling is applied to a complete fiction.
I'm not convinced by that line of reasoning because it ignores the physical constraints of trauma itself. You can't simply invent a gunshot wound. Physical evidence, like wound ballistics, provides irrefutable physical narratives that cannot simply be written away by a biased or tired officer. Physics doesn't take bribes.
Physics doesn't, but the person writing the report might.
But the lie would be immediately obvious to any secondary review. The mechanics of trauma dictate absolute rules. An entry wound from a firearm will fundamentally present with smaller, inverted edges, an abraded collar where the bullet scraped the skin, and if fired at close range, distinctive gunpowder tattooing. This physical reality can never, under any circumstances, be confused with an exit wound. An exit wound presents with larger, irregular, everted, or pushed out edges, and absolutely no burning or singeing because the bullet is leaving the body.
That is textbook ballistics, yes.
Nor can an entry or exit wound be confused with tangential gutter wounds that merely graze the surface without cavity penetration. The physics of the injury tell the story, and furthermore, the expert witness interpreting this is bound by rigorous legal thresholds to prevent exactly the kind of fraud you're worried about. Under Article 59 of the Qanun-e-Shahada in Pakistan and the Dauber Standard in the USA, the expert must legally prove the reliability of their scientific technique and demonstrate an absolute lack of bias. The system has built-in filtration mechanisms.
I come at it from a different way. You are assuming that the objective physical narrative seamlessly makes its way from the body, onto the paper, and into the final court decree without any distortion. But our source text explicitly highlights the bizarre discrepancies that occur in reality all the time.
Discrepancies are exceptions, not the rule.
They happen often enough to compromise the claim of infallibility. We frequently see cases where the police docket, the initial narrative of the crime, claims a blunt weapon, like a bat or a pipe, was utilized in an assault. Yet the medical report miraculously describes a linear incised wound, which requires a sharp edge. That is a total disconnect between the alleged history and the documented reality. It proves the system's massive susceptibility to human narrative framing.
But again, that's an error the system is designed to catch during cross-examination.
What about areas where the science is inherently subjective? Your reliance on physical certainty completely ignores domains like psychological autopsies. These are increasingly common in US and UK suicide investigations, where investigators try to profile a deceased person's mental state retroactively to determine if a death was an accident or a suicide. That is a highly subjective endeavor, masquerading as objective forensics.
It is an investigative tool, not the sole basis of a verdict.
Exactly. And that brings me to the most important philosophical point from our source material regarding the expert witness. The treatise says the expert is there to provide the court with the necessary scientific criteria so as to enable the judge to form their own independent judgment. The expert's opinion is a tool, not a verdict. And how is that tool delivered to the judge? Via the chain of custody, which is point 11 of the MLC.
The chain of custody is heavily documented.
But it is not a mathematical formula. The most advanced lock on a door doesn't matter if you leave the key under the mat. The chain of custody is a fragile human chain of first responders, transport officers, and lab technicians. If one human link fails, if one vial is mislabeled, if one swab is contaminated, your flawless entry and exit wound ballistics are entirely legally compromised. The science means nothing if the human chain breaks.
As we draw this discourse to a close, I maintain my stance that the deep integration of empirical science into the justice system has fundamentally secured absolute identification and objective truth. Yes, human systems have flaws, but by turning human biology into a definitive map for justice, whether through the 1 in a billion precision of STR analysis, the chemical certainty of GCMS toxicology, or the meticulous medical legal categorizations of Section 311 grievous injuries, which universally standardize the legal response to severe bodily harm, we have undeniably created a significantly safer, more accurate society. The silent witness provides a vital scientific baseline that ultimately transcends human memory, bias, and deception.
And while I concede that the science itself, the molecules, the chemical reactions, the physics of a ballistic trajectory, does not lie, we cannot ignore that the justice system is entirely operated by human beings. Therefore, it remains profoundly susceptible to fabricated medical histories, interpretive bias by experts acting as witnesses of opinion, and the inherently fragile nature of the chain of custody. More importantly, the mass expansion of genetic databases in the name of biometric security presents a severe privacy overreach. It proves that our technological capabilities have, in many ways, outpaced our societal and legal frameworks.
I believe we can both agree, however, that the aggressive push toward global standardization is a monumental achievement for the field. The fact that regional bodies like the PFSA in Pakistan are actively adopting international ISO standards ensures a baseline of scientific quality control that simply did not exist in previous decades.
Yes, we absolutely converge on that point. The advancement of methodologies, particularly non-invasive techniques like virtual CT and MRI autopsies, represents incredible human ingenuity. It is a necessary and highly positive evolution in the practice of legal medicine. It minimizes physical intrusion while maximizing diagnostic yield, allowing us to preserve truth without altering the evidence.
The intersection of absolute science and fallible human law makes medical jurisprudence one of the most complex and fascinating domains of our time. To truly understand the delicate balance between the immense utility of genetic data and the sanctity of privacy rights, or the intricate nuances of interpreting physical trauma in a courtroom, There's a vast amount of knowledge yet to be explored within these source treatises and global legal codes.
We leave it to the listener to weigh these realities, to consider whether the mathematical infallibility of the silent witness is enough to overcome the inherently interpretive, deeply human nature of our justice system.